Good morning. I'm Beverly Martin. I work for the Center on Civil Justice here at NYU, and we're delighted to have you this morning. I wanted to recognize Ken Raisler, one of our board members, and thank you for being here and supporting us. I also wanted to introduce you to Janet Sable, who's works with me at the center. I work with her, and same for David Siffert, who works at the center. And Mindy, who's just, yeah, there she is. She works with us as well. So I'm so delighted to be able to present this program, particularly with my friends here. There are probably more formal introductions I could give to Judge Garifas, but what I want to say about him is that he and I were in baby judge school together when we first became judges. He was kind of a standout from the beginning, and I believe now he teaches baby judge school, all the while being an outstanding United States District Judge in the Eastern District of New York. We share a law clerk. Judge Garifas trained Gabriel Panic and then sent him to me, and that was, I don't know why I didn't do that more often. That was a great thing. So he's beloved by many and respected by all. I'm going to let Judge Garifas introduce his panel.
All right, thank you. Thank you, Judge Martin, as Beverly. And I'd like to also thank David Siffert, who encouraged me to participate in the panel as the moderator. I'd like to thank the NYU Center of Civil Justice for convening this conference on nationwide injunctions. The subject has received a great deal of attention in the last decade from the courts, from academicians, public officials, and the media. Those of us who have, from time to time, utilized this tool have enjoyed both approbation and condemnation. We much prefer the former. We're fortunate to have with us today a distinguished panel to lead off this discussion. The panel includes Professor Michael Morley of the Florida State Law School, Professor Alan Trammell of the Washington and Lee Law School, Professor Jared Trujillo of the City University of New York Law School, and former Maine Attorney General and Harvard Law School lecturer James Tierney. So we have representation geographically from everywhere, including Queens, I'm happy to report. In recent years, there's been a proliferation of nationwide injunctions, which have become a predominant tool for challenging regulations of federal agencies and statutes that authorize them. The panel will provide a historical perspective on the development of nationwide injunctions, focusing on how they are primarily utilized by the courts and sought to be used by litigants. We'll examine the differences between class actions and nationwide injunctions, as well as the question of whether nationwide injunctions achieve Article III standing approval. And we're going to have an opportunity to hear from a former Attorney General of a state as to how the states get together to bring these cases and where they tend to bring them. Fortunately, we will not be discussing solutions because I'm not sure that there are any, but Professor Vladeck will lead the panel on that subject, I'm pleased to say. Of course, our panelists will have the opportunity to opine on what, if anything, they think is wrong about the current practice, and we look forward to hearing from Professor Vladeck's team on the solutions. I hope we will have a flowing discussion, and I encourage the panelists to question the ideas of each other. Having spoken to the panelists by Zoom on Friday, I don't think that will be a problem. We will reserve a little time at the end for questions from everyone in the room. And please feel free to raise your questions at the end. So let's begin with how we define a nationwide injunction and how the device has been utilized over the years. What I'm going to do is ask Professor Morley and then Professor Tramwell to lead us off on the history of nationwide injunctions. Welcome.
Thank you very much, and thank you all for coming, and I'd like to thank NYU for hosting this event. So if there's one thing that I can persuade you of by the end of this, especially you, Your Honor, it's that we should not be calling these nationwide injunctions. Calling these types of orders nationwide injunctions puts the focus on entirely the wrong aspect of these orders. It is completely unremarkable to say that a federal district judge's order can have nationwide effect. Right? If you obtain an injunction barring the government from enforcing a statute against you, the government can't resume enforcing that statute against you just because you happen to cross state lines, particularly if we're talking about the federal government here. The fact that orders have nationwide impact isn't the main issue. Rather, the issue is whose rights are being enforced. Rather than thinking about things in terms of nationwide injunctions or not, I suggest we think about them in terms of plaintiff-oriented versus defendant-oriented injunctions. A plaintiff-oriented injunction is an order tailored to enforcing the rights of the party plaintiffs before the court. If that's an individual, the individual. If it's a state plaintiff, then the state. If it's a plaintiff class, then members of that plaintiff class. Most rights are what we call divisible, meaning it is possible to enforce the rights of particular party plaintiffs without unnecessarily going further and issuing what I call a defendant-oriented injunction, which is what most people are referring to when they use the term nationwide injunction, which is an order saying you, government defendant, are not entitled to enforce this challenged legal provision against anyone, anywhere in the nation, including third-party non-litigants who aren't before the court and who may not even be within the court's personal jurisdiction. And one of the reasons I want to point out for switching the focus away from geography is that many of the issues that we're going to be talking about today arise equally if you're talking about statewide injunctions. Because again, there the question is whose rights are we going to enforce? The plaintiffs before the court or other third-party non-litigants by telling, again, the defendant, you can't enforce this challenged legal provision against anyone. So that's really the heart of the issue that we're going to be focusing on.
Professor Morley and I have had the pleasure of sparring about this for the last many, many years, since I think at least 2018. We've been on a number of panels together. There's nobody I would rather disagree with respectfully more than Professor Morley, and we do have our disagreements. But he has persuaded me that we are right, that he is right, that we should be thinking about these as defendant-oriented injunctions. At least the ones that have gotten so much national attention over the years are indeed focused on who is the defendant, prohibiting that defendant from engaging in certain conduct, not just with respect to the plaintiffs before the court, but with respect to everybody who is going to be affected. Now, through a modern lens, this seems problematic because in the overwhelming majority of situations, we have a superior mechanism for dealing with this problem of group harm, and that is a class action, and in particular, an injunctive class. The mere fact that we have that device, though, does not mean that nationwide injunctions are unconstitutional or even that they should never be used. There are going to be a number of situations where you can have group harm and yet a class action is not going to be feasible. Sometimes it's never even going to be possible. And so part of, I think, what our panel is going to be thinking about, and when we're going to be handing off the baton to Professor Vladek's panel, is situations in which it might make sense, but also ways that we can cabin the scope of this particular power that courts are going to exercise. But I do want to think about it in those terms, namely, what is the scope of this power? We will get into the fact that I don't think that they are unconstitutional. A lot of scholars will trace the advent of nationwide injunctions to about the 1960s. The Department of Justice under President Trump often, I was about to say flog that line, but that's going to weight my, my assessment of this. They repeated this over and over, that nationwide injunctions trace only to the 1960s. That is not correct. Professor Mila Sahoni has demonstrated that these kinds of injunctions, these defendant-oriented injunctions, trace back much earlier. The Supreme Court issued arguably the first such injunction in 1913. It also approved of injunctions going back perhaps even a couple of decades before that into the late 19th century. So we actually do have some precedent. Now, we're going to be grappling with why it is that starting in the 1960s, particularly in the administrative law context, we see this rise of injunctions that are extending beyond just the plaintiffs who are actually before the court. To tease where I want to go with this in a later discussion, I think that we can't divorce these so-called nationwide injunctions, whether those are defendant-oriented, universal injunctions, whatever you want to call them, from broader remedial developments in the 1960s. The 1960s is when we see the rise of the prophylactic injunction. We see the rise of Section 1983 as one of the most powerful civil rights statutes in the federal government's arsenal today. That comes about in Monroe versus Pape in the 1960s. And we see that all of this, in a lot of ways, is a response to increasing lawlessness. Just to take one very, very obvious example, Southern school boards that refused integration orders in the 1960s and in the 1970s. And in the face of that lawlessness, federal courts were asking, what can we do to essentially ensure that governmental actors in particular are going to be adhering to their obligations? How do we vindicate these rights when there is an active effort to undermine them? So again, even though I think that there is this tendency to talk about them as tracing only to the 1960s, there is a broader tradition, and I hope that we can at least tee up the basic problems and then let Steve's panel solve all the problems.
Professor Trujillo, would you like to add anything on the subject?
I think that's a good, thinking about these as defendant versus, or as defendant oriented injunctions is a useful framework. I would just add that, and I think the next panel will get into this in a little bit more depth, but I think there is also a real political issue with injunctions as far as how the public views, the next panel will get more into forum shopping, but how the panel views this power from Article III courts. Right now we have a Supreme Court that's really losing a lot of who has lost just a lot of confidence from the public. And the reality is that when someone can go and get an injunction from one court where maybe another district court in another jurisdiction denied a party relief, it just looks really bad, and it just reinforces the public's perception that that Article III courts are political entities, not entities that are enforcing what the law is.
Well, let me mention a real case that I had nothing to do with in the Eastern District of New York. The Trump administration decided to start removing DACA recipients from the country and started putting DACA recipients on airplanes at Kennedy Airport. And I don't know which of the, I don't recall which of the organizations that represented immigrants, but the ACLU may have been involved in other organizations, went to the Eastern District of New York for a preliminary injunction to bar the administration from deporting people without due process. And they didn't have the names of all the people. They didn't particularly represent these individuals, but they represented what you would call a class. It wasn't an official class because it was a brand new litigation, and there's a process. So they went to a judge who was the weekend judge at the Eastern District of New York, and they got a preliminary injunction or a restraining order and took it to the airport and delivered it to the airlines, which forced the airlines to be in a position where either they would put people on airplanes who were DACA recipients and risk being in violation of a court order, or not put them on the airplanes and risk being sanctioned by the Trump administration. It got to the point where several Congress members went to the airport, specifically in this case Congressman Nadler and Congresswoman Nydia Velázquez, and they delivered the court order to the airlines. One of the planes had taken off, and they demanded that the plane turn around and bring the individuals who had been placed on the plane back, which they did. All right? So my question to Professor Morley is, there are circumstances where without having a distinct individual, there is a group of individuals that can be identified clearly who may be the subject of an illegal act, and that an injunctive relief is the only way to secure their immediate rights, the immediate protection of their rights. Is there not?
No, there's not. There would be at least two ways for a situation like that to be handled. Number one, the plaintiff organization could attempt to assert organizational standing, showing that deporting any of the DACA recipients without due process would cause injury, in fact, to the organization itself in terms of reallocation of resources, making it harder for it to achieve its goals of defending those individuals' due process rights. And so asserting organizational standing would be a way of achieving, through a plaintiff-oriented injunction, an injunction tailored to enforcing the rights of that plaintiff organization, relief that has the collateral incidental effect of benefiting third parties, but it would not be a defendant-oriented injunction because it is not unnecessarily going beyond enforcing the rights of the party plaintiff before the court. The other approach would be filing the case as a putative class action and as an assessment of the likelihood of success on the merits. Again, it's an emergency situation, it's ex parte, but to the extent the court takes even a preliminary look at the merits, the likelihood based on the record before the court of the class being certified would be a factor that would allow the court to say, okay, this is a putative class action. Based on the likelihood of success on the merits, I'm going to give this interim emergency class-wide relief, but on the premise, again, that this is a putative class. And there are other Article III situations, by the way, where the Supreme Court does treat putative class actions, even ones that haven't been certified, differently than non-class suits altogether. For instance, if a plaintiff's claim in a putative class action suit becomes mooted, even though the class hasn't been certified yet, the Supreme Court says because this is a putative class action, that's enough to keep the case live. The interests of the putative class members are enough to keep the case live. And so I think that would carry over as well to the context of emergency ex parte proceedings.
Anybody else on that subject? Does that work universally?
No. Both start our answers off with no. I don't think so. I mean, I hear all of the very creative arguments that Professor Morley is making. Number one, would any of those avenues be available in the example that Judge Garofas cited. I don't think that any of that could have proceeded quickly enough to get planes to turn around. I could be wrong about that. Now, maybe we shouldn't let one case drive our thinking about the constitutionality or the advisability of these broad-based injunctions, but I don't think that those are successful rejoinders. And I would say that the other thing to bear in mind is that there's a certain path dependency here. The Supreme Court has, as most of us know, restricted the availability of standing in so many situations. And the idea that an organization would be able to say, oh, well, our organizational interest would be harmed if you don't turn the plane around, if you don't admit green card holders to the country, I don't think would necessarily fly. Maybe it would, but in light of various cases that arose from the Trump years, I think that the Supreme Court has told us that that is going to be a much, much harder argument to make in this situation.
Mr. Tierney.
Yeah,
Attorney General Tierney.
I'm going to call these nationwide injunctions with all due respect for the primary reason is that that's what the conference is called. So, I mean, you know, it's a conference on nationwide injunctions. And clearly we have a problem. If we didn't have a problem, we wouldn't be gathered to have this conversation. It's a problem that strikes at the core of governance. And regardless of what history you want to do, I'm here to talk to you about attorneys general. I've read the materials, all three of my panelists. I've learned a great deal in the last couple of weeks getting ready for this. But what I know about is attorneys general for the last 40 years, not only because I did the job in my own little state, but also since then I've consulted on management and legal issues for over half of the states, and I've taught about the attorneys general for the last 20 years, wrote a case book, all those kinds of things. And the reason I mention it is that in all of the readings, and frankly in the preliminary discussion here about classes, there's a fundamental misunderstanding of how attorneys general approach their jobs and how they define their situations. Attorney general doesn't need a class. Attorney general is the attorney general. And they get standing because the Supreme Court says they do. And so all of the discussions about putative class actions and how do you formulate are all just fundamentally irrelevant if you have an attorney general on your side. This goes back to a 2006 case, Massachusetts versus EPA, in which I was at Columbia at the time. We incubated a group of attorneys general and interest groups who somehow felt that global warming was a problem. I don't know why we thought that, but we did, and that we thought carbon dioxide ought to be regulated, as did the EPA, the administrator of the EPA, all the lawyers at the EPA. But Vice President Cheney's energy group decided that carbon dioxide shouldn't be regulated. So we knew, since they had no real legal argument, if we could get to standing, we as a collection of attorneys general, states, mayors, and so on, we knew that we would win. So, because there's really no defense. So what happened in that case was fascinating. When it got to the Supreme Court, there were 19 parties, plus a couple states. The Supreme Court denied standing to everybody except the Commonwealth of Massachusetts. And they said, well, Massachusetts has some beaches, and the water might rise, and so therefore Massachusetts has standing. Well, we were surprised. That hadn't been argued by anybody. And Justice Stevens said, we're going to give special solicitude to the states. And this special enhanced standing, if you will, creates a funnel into the offices of attorneys general, which I can go on in great detail about, which I won't in this answer. But the answer to your initial question is, had an attorney general sought that initial injunction, you know, in your case, then you would have had, you know, a better chance of getting past the standing issue and into the merits, notwithstanding the substantial work by numerous non-governmental organizations and entities and we all remember that weekend, race to the airport. Because, to put it bluntly, every attorney general I know or have known thinks they represent everybody. Not just in their own state, but everywhere. That's what happens when you get to be attorney general. You know, everyone stands up when you walk in the room and they applaud. You have this great respect, and pretty soon you start to believe it. And so they will continue to bring cases seeking nationwide injunctions, plaintiff or defendant, depending on the issue, depending on who's the president, until they're not going to stop until, until the judiciary figures out an answer to this problem. If that helps.
Well, I think it's important to distinguish between two distinct issues. On the one hand, yes, right, under Massachusetts EPA, for however long special solicitude remains in effect, which the Supreme Court has been sending some mixed messages on that at best. But it's arguably easier for an attorney general on behalf of the state to get into federal court. But the question then still remains, what relief does the attorney general on behalf of the state have standing to seek? Just because you're an attorney general doesn't mean you automatically get to seek a defendant-oriented injunction completely barring the government from enforcing the challenge legal provisions against anyone anywhere. Even an attorney general representing a state still has to show why the relief they're seeking is necessary to redress the injury in fact their state has suffered, right? So when Texas goes into court trying to challenge restrictions on undocumented migrants, they have to try to show if they want complete invalidation of more liberalized criteria, they have to show that allowing undocumented migrants anywhere into the nation is going to cost them an extra $1.50 for their driver's license or whatever it was their injury in fact argument was. And that's a very hard row for them to sow, which is exactly why you see coalitions of states trying to come together. The argument basically being, well, if you have enough states, then that might be enough as a practical matter to require complete invalidation of the challenged legal provision. But even with an attorney general who's able to assert standing, right, the Supreme Court has said you not only have standing for each cause of action, but you have to have standing for each remedy that you seek. And that doesn't completely alleviate the question of showing that a defendant-oriented injunction, a nationwide injunction, is necessary to redress the injury in fact that got you into federal court in the first place.
It's very nice logic, but it's simply not true. It's not remotely true. Any given state can get there. If you remember, the last case on the travel ban was the little state of Hawaii, 1 million people. They're the final case that went to the Supreme Court seeking the remedy they sought. And the most recent embarrassment from the Supreme Court, well, there are many, but the particular one of Nebraska versus Biden, I think was sort of extraordinary. It was clear that the United States Supreme Court didn't like the student loan deal. They wanted to strike it down. They didn't like it. There are things I didn't like about it, too. But, I'm not, the Congress or the president looked at it differently. So they said they had to scrounge around to find, there were 5 or 6 states that sued. They had to scrounge around to find one of them that had standing. They only had one that found standing, very thin, state of Missouri. And then the Supreme Court said, thank goodness, we'll give Missouri standing, and then we'll strike the whole program down. 26 million people, we don't like this program. So as long as you have the Supreme Court saying yes to letting a state in and then granting stunning relief, all of the articles and all of the thoughts really aren't going to make any difference. It's going to come back to the court. See, because standing is like an accordion. It opens and it closes depending on the music that the judge or the justices want to hear. It's really that simple. Now, Professor Vladeck basically said after Nebraska versus Biden in an interview, this means that any AG can get anything they want. Hopefully that's not true. I think it's an overstatement of the point. But Justice Kagan's dissent in the case Nebraska versus Biden is very, very persuasive. She makes this clear. There is no standing from these states at all by any remote standing, but the court wanted to strike down this program, so they just did. And that's the world in which we're living in. It's part of the reasons that there's less respect for the Supreme Court across the academy, across practices of law. You talk about what may be constitutional and what's not constitutional. Frankly, none of us know what's constitutional from day to day. We're going to have to figure that out when the justices rule, to a degree which is tremendously unsettling. But we'll stick to nationwide injunction at the moment. But it's simply what you said, not true. You don't need a coalition of states. It doesn't make any difference, nor should it make any difference how many states have sued. It doesn't make any difference whether it's California and New York or whether it's Hawaii and Vermont.
Anyone else on the subject? Okay.
I'll just add very, very briefly that I think that all of this demonstrates why standing is the wrong constitutional home for most of these arguments. As Jim says, it is like an accordion, and you can think back to even some decisions that I would very much agree with, like the Windsor opinion. And Justice Scalia in dissent says the court was just yearning to pronounce its view on same-sex marriage, and it fudged the standing inquiry along the way. Now, I think that it's actually a very complicated question in Windsor, but so many of the arguments about these nationwide, universal, or defendant-oriented injunctions, whatever you want to call them, tend to be couched in terms of standing. The Trump Justice Department did that. I think that that is wrong because it is pretty clear that in almost all of these instances, maybe leaving aside the student loan case, when you have individual plaintiffs, you have somebody who has suffered an injury in fact. They do have standing. The Supreme Court, yes, has said that you need standing for each remedy that you seek. We can query whether that is stretching the doctrine a little bit too far. But what it has never said is that standing is relevant to the scope of the remedy that is being sought. And that makes sense because if a judge grants a remedy that is too broad or too encompassing, that doesn't somehow suggest that the court was without jurisdiction, that this was totally unconstitutional. That is simply called reversible error. And an appellate court will then narrow the scope of the relief that is sought. We have historical examples of that, for instance, dating back to the 1930s when you have a nascent labor movement. You had these labor injunctions that were being issued far too readily. Congress responded. It said, with the Norris-LaGuardia Act, we are going to restrict this remedy that is available for district courts to issue. It didn't say district courts were behaving unconstitutionally. It said you're jumping the gun. We think that you're getting out ahead of your skis, but there was nothing in the Constitution that somehow restricted the equitable power. Congress chose to tweak that. And again, I don't want to get ahead of what we should be doing here and work an incursion on Professor Vladek's panel. But it strikes me that the Constitution really is a red herring, and standing in particular is a red herring as we discuss this.
I'd like to push back on that a little bit. In every other context, this would be a completely unremarkable, easy case. Imagine a damages suit against the government, right? A government official, you're driving a car with a friend, a government official plows into you. You could sue the government for damages. A federal court would say, among other problems, you lack Article III standing to seek damages on behalf of your friend. In suits for equitable relief against private defendants, this is completely apparent. If Apple sues Samsung for patent infringement, Apple could seek an injunction preventing Samsung from infringing its patents. Among other problems, Apple would lack Article III standing to seek an injunction barring Samsung from violating anybody's patents or from violating Intel's patents. It would only have Article III standing to seek relief for itself. So yes, the problem is in terms of standing because, at least as the Supreme Court has articulated the test in Lujan, and we could have a whole separate fight, that's ahistorical, the court just made that up. You know, we're all legal realists now, so we just think the court's doing whatever it wants, case by case. But at least to the extent you take doctrine at least somewhat seriously, the notion that the relief that you seek must redress the injury in fact to you doesn't mean you have Article III standing to seek relief on behalf of third-party non-litigants who you've chosen not to bring into the case through a class action. And in terms of what the Supreme Court has said, the Supreme Court has told us injunctive relief should be no broader, more burdensome to the defendant than necessary to provide complete relief to the plaintiffs. Neither declaratory nor injunctive relief can directly interfere with enforcement of contested statutes or ordinances except with respect to the particular federal plaintiffs. This was Califano versus Yamasaki, Doran versus Salem in Inc. So in some respects, this really isn't a hard question. It's the fact that some district courts are doing this anyway, despite the background principles of standing, despite the numerous practical problems that we haven't even gotten to that come up, one of which being the concept of asymmetric preclusion, that no matter how many times an individual plaintiff wins, and no matter how many times an individual plaintiff loses, that ruling is not binding as a matter of res judicata or collateral estoppel on any other right holders. So other right holders could continue to litigate this case, potentially even in the same judicial district, since district court rulings have no stare decisis effect, but certainly in other districts, other circuits. Yet if anyone anywhere wins even a single case, then potentially that court could enter a nationwide defendant-oriented injunction, barring the government from enforcing that legal provision against anyone anywhere. And so that, the asymmetric stakes, the asymmetric preclusion, the fact that the government's first loss can effectively bar it from enforcing that challenge legal provision against anyone should give you pause. Right? The conflict with U.S. v. Mendoza, where the Supreme Court held that the government is not subject to, here's a mouthful, offensive non-mutual collateral estoppel, meaning that just because someone wins an issue against the government doesn't prevent the government from continuing to to defend the constitutionality of that legal provision or defend its interpretation of a statute in other courts and other jurisdictions. All of these problems, again, are, as Professor Trammell points out, go beyond Article 3, but they reinforce, they dovetail with the underlying Article 3 concerns here.
Well, I have a case that I decided having to do with DACA and the acting Secretary of Homeland Security, or the putative acting Secretary of Homeland Security, struck down the decision by the Obama administration to permit the DACA recipients to remain in the United States. And I conducted an analysis of whether the acting secretary was actually lawfully the acting secretary. And I found that he was not the acting secretary. The administration had not followed the proper procedure, and this person was illegally in the position of acting Secretary of Homeland Security. Does this mean if I rule that the acting secretary is not lawfully in place and cannot make such a ruling or strike a regulation because he doesn't meet the requirements of the law to become the acting secretary, that decision only applies to the plaintiff who's in front of me, and that everybody else who's being deported has to go to court to determine whether that individual is not the acting secretary in their case, or is it the obligation of the government to appeal me to the circuit court and to the Supreme Court so that my ruling on that subject can either be affirmed or reversed? In a situation where there are thousands of DACA recipients who are potentially going to be out of luck, what do we do in that case? By the way, the answer in the case of my situation was there was never an appeal, and so nothing else was done, and the regulation was not enforced, or the striking of the regulation was not enforced for the balance of the Trump administration. So I mean that's the tension between what you're saying, Professor Morley, and what I'm seeing out there, as an individual judge, and I didn't really have any choice. I actually said that someone who is legally in place as Secretary of Homeland Security has this authority, but this individual who just showed up and they didn't follow the rules about putting this person in place as the acting secretary didn't have the authority. So if he didn't have the authority for this plaintiff, he wouldn't have the authority for any plaintiff. That was my situation. And of course, I was the case of the day on Fox News as a result of that. But the photograph of me was excellent, so I didn't mind. What do you say about that? That's a situation where I would think, you wouldn't want a person who was not legally in office to be able to strike down the rights of people without at all.
Well, if a day or two before you issued your ruling, a federal district judge in the Middle District of Florida, let's say, said that, yes, this person was legally appointed, that certainly wouldn't foreclose you from being able to consider the issue yourself. That judge's rulings would not have any stare decisis impact on you. The government would not know, the other plaintiffs would not be bound by res judicata or collateral estoppel. And so if a single district judge's ruling affirming the legality of that person would not be binding on all other third-party non-litigants throughout the nation, I struggle to see why the opposite ruling, that if a single judge, no matter how many other judges have come to the opposite conclusion, if a single district judge finds that the person is unlawfully appointed, why that ruling, especially, again, it doesn't even have stare decisis effect within the district, why that ruling would somehow nevertheless bind not only the parties to the case as a matter of collateral estoppel or res judicata, and again, right, the plaintiffs could have brought a class action, the plaintiffs could assert organizational standing, the plaintiffs could do both, but why the ruling going one way would be binding throughout the nation and effectively preclude the government from relitigating the issue, whereas a ruling affirming the legality of the appointment would have no such effect.
Well, the ruling has only effect on one person, and that's the Secretary of Homeland Security. And unless there's an appeal from that, I have a right to find the Homeland Security Secretary in contempt of court for not following my ruling. And the solution is, I don't care what that judge said in Amarillo, Texas. You know, I'm going to enforce my ruling unless my circuit overturns my ruling. And so that's the risk that the government takes. A responsible executive and a responsible U.S. Attorney General will, if there's disagreement about that, will immediately move to overturn my ruling. And that's really what needs to happen. The injury, you know, there's a question of injury here. And I think, a lot of is going on in these situations. But the injury is only if my ruling is ignored. All right? The injury would be to this individual, but to many other individuals as well. So to require that I aggregate all the people who would be injured in order to effectuate, the authority to make this decision and to enforce it, I think is exceptionally unreasonable. And what I said was just follow the rules, and you could act in this way. But the rules are that you have to follow a certain protocol in order to be named the acting Secretary of Homeland Security. They never appealed me. They went out of business about 2 months later when we had a new administration. But if this had been the second year of the Trump administration, I expect they would have appealed to the circuit court, and we would have gotten a decision, or they would have named the new Secretary of Homeland Security, and the person would have been confirmed by the Senate, and they would have done the same thing, and it would have been lawful to do it.
Well, I think you're absolutely right, but I think that you're getting into there are two separate issues in play here. Number one, if a district court issues an injunction, even if a party thinks that it's erroneous, even if the party thinks that the court was acting outside of its jurisdiction, under the collateral bar rule, you still have to follow the injunction. You can't violate the injunction just because you believe it's erroneous. So even if the government does believe the injunction is overbroad, does improperly protect the rights of third-party non-litigants, you're absolutely right, Your Honor. Of course the government has to appeal it, because even the illegality of an injunction isn't a defense to contempt of court, right? Martin Luther King Jr. himself literally was in prison for violating an injunction that patently violated the First Amendment due to the collateral bar rule. And if you want to get 1Ls interested in civil procedure, that is how you open your class. But anyway. But that still doesn't address the issue of whether the underlying injunction was proper or not. So the question as to whether the court has the ability to give its ruling the force of law for third-party non-litigants, is a separate question from whether the government should have appealed it, which obviously, yes, the government 100% should have appealed it rather than violating it, even if it were erroneous.
Slight pushback because Professor Reinert's in the audience. Iqbal is the way to start off your civil procedure class and get students interested in civil procedure. I want to zoom out a little bit and acknowledge a whole lot of what Professor Morley has said about the problems of these sweeping injunctions, the problem of potentially conflicting injunctions, conflicting obligations, the fact that a hasty nationwide injunction could prematurely freeze the law. All of these are indeed potential problems. There are potential problems as we think about offensive, non-mutual issue preclusion. It's the civil procedure professor in me. I'm going to try to resist the temptation to go off on an hour-long lecture about that. But you have problems across a whole lot of these different remedial devices, whether you think about prophylactic injunctions, where federal district courts were essentially managing entire school systems or prisons that were not fulfilling their obligations under the Constitution to provide, say, adequate health care to people who are incarcerated. You can think about all sorts of potentials for abuse across these remedial devices. But the fact of the matter remains that when you have government that is actively trying to undermine its obligations under the law, again, we can trace this back at least to the 1960s when you're thinking about school boards resisting integration orders, when you are thinking about widespread systemic problems in mental hospitals, prisons, school systems, you name it. There is a way that under traditional equitable principles, courts can step in. This is just one more iteration where courts are trying to step in. Now, again, is there the potential for abuse? Absolutely. Have we seen instances where courts have been overly hasty in issuing these injunctions? Absolutely. But I think that, again, not to preview too much the next panel, but we should be grappling with what are the specific circumstances when these injunctions make sense. And the flip side of the coin is, what are the overwhelming situations in which we do not want to see courts exercising this kind of equitable discretion? And I think that there's a lot of agreement that, again, most of the time, we probably don't want courts doing this, but it doesn't obscure the fact that courts aren't powerless in the face of lawlessness.
Well, what about the use of class actions? I think, that's a much cleaner way of aggregating plaintiffs as opposed to lone wolf cases where an individual brings an action and tries to sweep away some government behavior and apply that nationwide. What are the benefits of class actions, and have you seen them work better than or not as well as injunctive actions by individuals or even associational groups?
I think that the class action is usually going to be a superior device. It is interesting, though, that our modern injunctive class action comes from 1966. Yet again, an innovation where we see resistance to lawful orders by courts, and a class action, an injunctive class, was specifically designed with integration lawsuits in mind. It would be very odd to say that this device that did not emerge until 1966 tells us that everything that had happened before 1966 was somehow unlawful or unconstitutional. This is yet again another remedial innovation. And I think that it makes a ton of sense to resort to a class action. Make sure that we are checking the boxes, not just to check boxes, but to figure out whether we indeed have a cohesive class where people are on the same wavelength in terms of the relief that they are seeking, whether there are internal conflicts within the class. The device is great in so many instances at assessing these prudential concerns that should be motivating the deployment of many of these remedial devices. So it absolutely makes sense, and just because it's convenient to skip over the class action device and seek, for instance, a universal injunction doesn't mean that individual litigants or that courts should do that. But again, I think that there are situations where class actions are not going to be successful, perhaps because the absolute speed is necessary, or in situations where a class action is something that a group of plaintiffs will not pursue. Think about FOIA. There is no incentive for plaintiffs to get together in a class action. It's way more cumbersome. There is not any kind of relief that they can get that they couldn't get individually, that is to say, a document that they're requesting from the government. Moreover, precisely because of the asymmetric preclusion principles that Professor Morley has alluded to, there's actually a disadvantage in FOIA litigation for class actions. There's a huge incentive for each plaintiff to proceed in seriatim fashion, so that if they lose, somebody else could then come along and try to develop better arguments. Maybe this should not be how things should happen. Congress can reform FOIA, but the fact of the matter is that as it currently exists, FOIA is a pretty nice example of why plaintiffs are not going to pursue class actions, and a court's not really going to be in a position to say, no, I want you to get everybody who's similarly situated together, then and only then will I consider your arguments. It's just not a feasible solution.
If I can push back a little bit, I'm with you 80% of the way there.
I'll take that. That's a low B. I will take that.
We're making progress.
Number one, pre-1966, most of what is argued to be nationwide injunctions, in fact, were either issued in class action cases, associational standing cases. A handful of them were statewide injunctions in situations where you had a single district judge in the state. So yes, technically they, under my view, technically they violated Article 3, but this was an era where you had 3-judge district courts with direct appeal as of right to the U.S. Supreme Court. So you knew you were getting the same judge in any future litigation, probably combined with at least 1 or 2 of the other same judges in any future litigation. So as a practical matter, in the handful of cases where statewide relief was granted, even in individual plaintiff cases, it didn't matter. There wasn't an incentive to litigate the issue. And in some of these cases, the government even just consented to statewide relief because they didn't want to be selectively enforcing particular programs. So the pre-1966 story, yes, you will find a handful of examples, but many of the examples, in fact, are materially distinguishable. In terms of why Rule 23, like why bother going through this process altogether, apart from the abstract reasons in that once you have the class before the court, the plaintiff class has standing to seek relief on behalf of all right holders. Beyond that, you have the concrete nuts and bolts issue of preclusion. Once you have all the right holders before the court, they all stand to benefit from a favorable ruling, and they all stand to have their rights adjudicated to the contrary with an unfavorable ruling. In contrast to defendant-oriented injunctions, where all right holders stand to benefit from a favorable ruling, but only the particular plaintiff before the court stands to be precluded from an unfavorable ruling. So particularly from notions of fairness, certainly from the government's perspective, there's important reasons for proceeding under Rule 23 rather than going outside the rule. And I would suggest the existence of Rule 23 itself is independently important, that issuing defendant-oriented injunctions, providing effectively class-wide relief without going through the procedures of Rule 23, without satisfying the substantive requirements of Rule 23, violates Rule 23. The Supreme Court just a few years ago held district courts are not free to have de facto class actions or to treat lawsuits as if they're class actions when they're not, and that principle, I suggest, should carry over in determining the proper scope of an injunction. in terms of the issue of speed that we've repeatedly heard referred to, for Rule 23b2 class actions, there's no requirement of notice, there's no requirement for an opportunity to opt out. So particularly at the stage of seeking emergency relief, we're talking about literally adding maybe an extra page to the complaint, maybe adding like 5 or 6 extra allegations to the complaint about everybody's rights, or the plaintiff is similarly situated, everybody is similarly situated, right? Walking through the Rule 23 elements. And the final point I'll just quickly raise, because some of the examples that have come up implicated this. There are some cases where completely appropriate, completely unremarkable plaintiff-oriented injunctions are going to look a lot like a nationwide injunction, or are going to look a lot like a defendant-oriented injunction. And desegregation is a classic example of this. Redistricting is a classic example of this. If you go to federal court and you say, my congressional district is too big, it's violating one person, one vote, if you win, right, the federal court can't draw you your own personal set of congressional districts that only apply to you. Right? That is literally impossible. That's what we call that's what's called an inseparable right. That in enforcing the rights of the party plaintiff before the court inevitably, inexorably has to enforce the rights of other third-party non-litigants. Likewise, there's no such thing as a school district that's desegregated for just one student. In enforcing a particular student's equal protection rights, the court necessarily has to enforce the rights of other third-party non-litigants. The real dispute here is cases involving severable rights, where it is possible to enforce the rights of the parties plaintiffs before the court without going further and enforcing the rights of third-party non-litigants. And that's where we get into the jurisdictional issues, the standing issues, the preclusion issues, the structural issues, the fact that Congress chose to create the federal courts as a hierarchical, decentralized system where rulings of one circuit don't have stare decisis effect in other circuits. Right? Congress could have structured district courts like the Court of International Trade, right, where they have nationwide jurisdiction over all constitutional issues, for example, but they didn't. Congress chose a different path under the Everett Act of 1891, and at the very least, right, nationwide defendant-oriented injunctions are in tension with that structural determination.
Look, I'm not going to enter that discussion. I only understand about 10% of it. As you guys go back and forth, I have no idea what you're talking about. But what really focuses...
Join my students.
I don't know what you're talking about. But the question...
They don't know what I'm talking about.
The question is, they just both made the argument of why, when the marbles are all there in the pot, when somebody's real constitutional right is on the line, whether who's going to come into the country or not, whether someone's going to be able to have a medication to terminate a pregnancy or not, whether people are going to be able to marry the person they love. In all of these cases, it is the state that obviates all of this. All this discussion of they're the ones who are in the case. The states have understood that and developed essentially, as I mentioned earlier, a funnel for these cases. Interest groups, state agencies. In the state of Texas, one assistant AG's job is to read the Federal Register every day, looking for a regulation that the Attorney General just might want to challenge. And when they decide to go, they just go. When you have a class, no matter how carefully constructed, the person who doesn't want the injunction has so many different ways to challenge a class. It's not this, it's not that, it's over-inclusive, it's under-inclusive. And when you're in a hurry, and these cases are oftentimes in a hurry, it is the state has been empowered by the Supreme Court to be able to bring these cases, and that's why on the big ones, they're the ones that do.
And is it better to have a group of states, and how does that happen? Since you're not on the next panel, I'm going to ask you the question
that's easy.
Of the way it works.
That's easy. Sure, the way it works. I don't think legally it makes any difference whether it's one state or a whole bunch of states. But I think judges pay attention to who else is intervening and who else is filing amicus briefs. I think they pay attention. How the states do it, take a minute, because there are two things that are going on separately. On the political side, the Supreme Court has eliminated basically meaningful campaign finance reform, which means that no attorney general, except probably California and New York, raises most of their campaign money from within their state. It comes from somewhere else. Even they don't know because it's being funneled in through dark money sources. And both political parties have organizations, the Republican and Democratic organization. The Republican one was founded by Judge Pryor while he was the Attorney General of Alabama. And they raise tons of money. And they have conferences 6 times a year. And so all the attorneys general know each other. There aren't many, right? 50 AGs, maybe only 40 participate. That's about how many we've got in the room. There's a small group. Everybody knows everybody. Everybody's very respectful. The vast majority of work in an AG's office has nothing to do with this, and it's not political. It's not partisan. But when we're talking about these issues, you're either on the red team or the blue team. You don't see any AG jumping the fence to join the other side on all these big issues. So while that's done at the AG political level, then you have the assistant AG level. So assistant AGs come in, and they don't really touch most of the operations of their office, but they do gather around them a select group of 5, 6, 8 people who share their values. Elections have consequences. It's not a bad thing. And those very skilled lawyers are the ones who drive this engine, which is what you were asking about. They're the ones. Now, one of them will be called the Solicitor General, and it's important to know that the state Solicitor General is not like the federal Solicitor General. State Solicitor General doesn't have to be confirmed by anyone. The state Solicitor General does what the Attorney General of the state tells them to do. They're not independent actors. Now, they themselves write endless articles about how that's not true, but it's true. They do what they're told. So what happens here is the most ideological on both the left and the right are the ones that drive this agenda. The most liberal or the most conservative are the ones, and because we have a Democratic president, we see the issue being driven primarily by the most, not just Republican attorneys general, but by the most conservative attorneys general. And so these solicitor generals all know each other. They swap ideas back and forth. An idea might arise in Wisconsin, but because you clerked with the SG who's down in Texas or Louisiana, you flip the case down to them. They've got a better forum. You want to be in the Fifth Circuit, obviously, if you're challenging the Biden administration. So that's how this works. And they're very collegial. I've spoken to many, many meetings of SGs. Everybody gets along, a very friendly group. When I do role plays, I make Team Red act as, Team Blue, and Team Blue act as Team Red, as I take them through my little pedagogical exercises with the SGs. But that's how it works. And it moves very, very, very quickly. These are very talented lawyers. This isn't about some lobbyists getting the AG in the corner and twisting their arm to get them to do something. They're deeply committed. Both sets of attorneys general, this is a change. This is a substantial change in the last 5 to 6 years. You are completely vetted to be pure blue or pure red, or you don't get to be Attorney General, and you don't get to be Solicitor General. On the Republican side, the Solicitor Generals, I find this very disturbing, but it's the way it is. Maybe the Democrats will replicate it if there's a Republican president. The Solicitor Generals, the majority of them, don't come from the states where they're working. They don't come from the state. They come from somewhere else. I had the Solicitor General, terrific guy from Mississippi, zoom into my class the other day. He's in California, practices law in Chicago, never set foot in Mississippi, and he ends up arguing Dobbs. State solicitors traditionally have been there to understand their nuances of their state government, their state agencies, to make sure that appellate cases are handled consistently. But these individuals come in for national reasons. They're national players. Judge Van Dyke in the Ninth Circuit is a perfect example. He started off as Deputy Solicitor General in Texas, and he bopped up to Montana, where he was from. He was Solicitor General of Montana, ran for the Supreme Court, lost. Decided he'd leave there and become the Solicitor General of Nevada. So he went down Nevada. So these are national players that go from state to state, and they are national players. And when they are done, they don't stay in their states. They go back to the big law firm from whence they came. Or they go to the judiciary, depending on who's president. And so that is a machine, if you will, which has evolved in the however many years it's been since 2006, 15, 16 years, which didn't exist when you're looking at your historical models. You're looking, even in the early days of Obama, this system didn't exist, but it sure exists now. And it can be turned around instantly, and of course, does go to the second panel, which is you're going to go look and hunt and peck until you can find a judge because you were sitting in Wisconsin or you're sitting in Kansas and you're saying, no, I don't trust that judge. I'm going to send it to Louisiana because we're going to have a better shot. And that's where these came from. And that, my friends, is what we call nationwide injunctions. And it is a very bad thing for governance. As the U.S. Supreme Court launches yet another attack on the administrative state, which I thought they'd polished off last session with major questions doctrine, they're not done yet. This issue is going to emerge and reemerge unless some sort of reform comes from someplace. It's not going to come from the AG community. It's not going to come from the AG community. These lawsuits are very popular at home, and they win. Once you can choose your judge, you're going to win. If you look at the numbers, they get injunctions. This is a very successful, strategic litigation mode. And it's very popular back home. Take the question of choice. Every Democratic attorney general is pro-choice. Every single Republican AG is pro-life. And you don't represent the other side. Just a few years ago, the Attorney General of Illinois, who was pro-choice, represented pro-life statutes. Doesn't happen anymore. The Attorney General of New York decided she didn't want to represent the governor on immigration, so she just stopped. I don't know who she represents now, but private counsel represents the governor of New York on immigration issues. And I love the Attorney General of New York. I think she's fabulous. But she just decided it was a one-day story. It didn't even register. AGs are independent political players. They're elected in 43 states. Only 2 states, Wyoming and Alaska, can the governor remove the Attorney General for any reason.
Well, the Attorney General of New York has the obligation to represent the state in all matters affecting the state. And in fact, you know, as a judge, in one case, the Attorney General didn't indicate that she had a conflict. And so I insisted that even if she wanted to have co-counsel who was private counsel, that she had to have her Assistant Attorney General also on the case because she had no basis for reneging on her obligation.
Spoken like a true former Assistant Attorney General from the left court's days.
That's right.
And as recently as Attorney General Spitzer and I would get into these arguments, he loves to argue, if you've ever had the occasion. I was trying to get him to not represent Governor Pataki on something. And he said, Jim, I am going to run against Pataki and I am going to beat him. But as long as I am the Attorney General, I will find an argument to defend his action. I am the lawyer for the state. What I'm saying is, in the last 4 or 5 years, that practice has, I'm not saying it's going to stop, but it has significantly changed. And as attorneys general become more independent, their funding sources for campaigns and advocacy groups come streaming in from undisclosed locations, then they are going to continue to do this until someone stops them. They are not going to stop themselves. This will have to come from another source, from the Congress. We know how efficient they have been operating lately, or it's going to come from the judiciary itself in some manner of reform. But they're not going to stop because it's very popular at home. To use the choice issue, I know I'm talking a lot, but it's an important issue. In virtually every state, the polls show that it's about 60-40 pro-choice, right? Kansas, Kentucky, you know. But if you're the Attorney General, if you're the red or blue Attorney General, your base isn't 60-40 anything. Your base is 100% one way or the other. And that is where your litigation is. I track very closely. I teach the role of attorneys general on abortion. And I'm yet to see a pro-choice attorney general do anything but take the most strong pro-choice position, or a pro-life attorney general to take anything other than the most strong and strenuous pro-life position. So that's kind of where we are. Maybe it's why I'm on the panel, but it's a significant problem. I do not think elected officials should be in this position to have this extraordinary authority that the Supreme Court has granted them to let them do what Missouri did to strike down 26 million people from whether they have to pay their student loans or not. It's an extraordinary authority. They're not geared for it. Very small groups of people are doing it. They're highly ideological. It's not a good place. There, short question.
Anybody
long
else?
Answer.
And I think the same ideological pressures that are pushing attorneys general to be so polarized are a lot of those same advocacy pressures that oftentimes push the federal government to take whatever state action that they might take. I think about the guidance that the Obama administration issued around the use of bathrooms. It wasn't just that the Obama administration decided one day, we really care about trans kids, so we're going to issue this guidance for around bathrooms throughout the country. It was the practical reality is that a lot of advocacy groups made them do it. The ACLU, Lambda Legal, GLSEN, a lot of other groups made them, pushed them to do it. And we've spoken a lot already about what asymmetrical preclusion looks like, and the fact that the federal government might be precluded from doing something because an AG in whatever state files a case or gets an injunction. But the reality is that the federal government is also representing very real people and very real advocacy groups. And so if the AG in Utah is able to get an injunction, that really necessarily affects the rights and the advocacy and the very real interest of a lot of the groups that pushed the federal government to do something in the first place.
And how do we, one step further, so how do you protect against that becoming the norm, that an advocacy group goes to a place that is going to be fertile ground for reaching a certain conclusion and possibly result in the entire country being forced to live by the outcome in that location?
Well, that's why I'm not on the second panel. And frankly, as someone who's spent their career fighting government overreach, I also do think that there is a benefit in a lot of ways to different interest groups being able to go and to challenge a government action. If a government action is, if an action from the federal government is found to be unconstitutional in Louisiana, then that's great. But if it's found to be unconstitutional, if it's not found to be unconstitutional in Louisiana, or if a judge in Louisiana is not willing to issue an injunction, I don't see why that organization, whether it be the ACLU or Heritage Foundation, shouldn't be able to challenge that in Illinois or somewhere else.
I agree. That's democracy. And AGs are perfectly situated to be places, as is the federal government, to hear from advocacy groups on all sides and make the right decision. You're not making the right decision when you're sitting in your office reading every single federal register to come up so you can go file a lawsuit. That's not listening to anybody except yourself and your own particular ideology, and that's too much authority to give to any partisan elected official. You're absolutely correct. I agree with you. That's democracy. That's what we're supposed to do.
I'll just chime in to add from a doctrinal perspective. The imbalance that we're seeing in part traces back to Massachusetts versus EPA. So states, and in particular state SGs and AGs, are empowered to go out and
AGs, SGs do what they're told.
Okay.
Don't
I've
fall
been schooled
in,
on that.
No, but our law students walk around saying, "Boy, I'd love to work. I can't stand the AG, but boy, I'd love to work for an SG." No, this is fantasy promulgated by the SGs themselves. They like to write a lot, write articles, especially when it's embarrassing. I set up SG offices all over the country, so I gave the country both Ted Cruz and Rich Cordray, depending on how you look at it. You can blame me or praise me, depending on how you look at it. Sorry, Alan. I love you, but I wanted to make the point. It's the AG who's in charge.
State officials have been empowered, through Massachusetts versus EPA. And then the standing jurisprudence that I was alluding to earlier is at least making it harder for organizations like the ACLU or Heritage or any others to get in court. So it is not a level playing field when you are talking about state versus non-state entities in terms of being able to get into court. And I very much agree, I think, with all of my panelists that we should not be so quick to freeze the first decision in place. That is a prudential matter, though, and that is not something that necessarily speaks to the constitutionality of a nationwide injunction, but we have dealt with these same problems in the context of non-mutual preclusion, making sure that the first person to a final judgment doesn't freeze that for everybody who is similarly situated, whether that is technically in class litigation or not in class litigation. There are all sorts of prudential pitfalls that we generally trust courts to be attuned to, and when they're not, there are ways that state actors can push back. There are ways that legislatures can push back on that. But again, as a normative matter, I think that there is broad agreement that we should be encouraging multiple voices to go into court to be heard on these issues.
Absolutely, I agree.
You know, I will say that when I have a matter before me that's been handled by other judges, I will look at what the other judges did, because I think it's instructive to see what they thought and what they concluded. And I may find that there are substantial differences in what was before them than is before me, or I may find that it's virtually identical. And then the question is, why would I reach a different conclusion? Do I feel impelled to reach a different conclusion, or am I going to be convinced that it makes sense to reach the same conclusion? And so it's of course, I also ask, you know, when my law clerk says, you know, this court in California or this court in Minnesota, I'll also ask, who was the judge? Because and more so because I'm concerned about the thinking, you know, the competence and the judge's reputation as I am about what the judge did. Because it's very helpful to have smart people helping you to do your job. Your law clerks who you select and other judges who somebody else selects. So I won't say who I, you know, look at with great, you know, respect and who I don't, but that's, after more than 23 years on the bench, I find that it's useful. And I think as well that having sat by designation on the circuit court repeatedly, circuit judges look at that too. So they're looking at what to do, but they're impressed by the thinking of certain district judges, whether they are from my own circuit or from another circuit. They tend to know who, you know, is going to give them a roadmap, and so that's how judges, I think many judges, look at some of these difficult decisions that they have to make. So, questions. There's a question in the back from Professor Vladeck.
So you all did a nice job of punting the hard questions to our panel. So I'm going to take the opportunity to kick it back to you for a second. The conversation seemed to shift in a way that makes me wonder just how big a deal non-plaintiff specific or defendant-oriented injunctions really are, right, compared to all of the other forces and pressures that we're seeing in contemporary civil litigation. So, you know, just thinking off the top of my head about some of the most visible recent examples, the social media jawboning case in which the Supreme Court issued a stay on Friday, the mifepristone case, right? I mean, these all strike me as examples of either context in which no one really cares that the injunctions are not plaintiff-specific, or context in which even if it was formally possible for the defendant to separate out, to sever, to use Professor Morley's term, the plaintiffs from non-parties, practically it's not, right? I mean, DOJ is not going to, you know, or DHS is not going to enforce immigration rules against some people and not others, or in some cases not others. And all of this leads me to wonder if all of the ink being spilled over the propriety, the origins, the provenance of non-plaintiff non-plaintiff injunctions is distracting us from what would be true anyway. So I want to ask you guys to imagine a world in which Professor Morley has won and there are no more and there are no more non-plaintiff specific injunctions, would anything about the most visible cases that we're seeing today and that the Supreme Court is dealing with actually be different? And I'll just confess that my skepticism and part of why I think we're having the second panel is because I'm not sure the answer is yes.
I think it varies, right? I think that there are going to be some circumstances where cases will just be brought as Rule 23b2 class actions. I think there will be some cases where plaintiffs, whether it is states or organizations, will be able to show that complete suspension of a statute, complete invalidation of a statute is necessary to preclude the injury in fact to themselves. I think there are other cases, as you correctly point out, where just due to logistical concerns, administrative concerns, the government doesn't want to have a separate rules applying to different groups of people, even if technically a legal provision has been enjoined only with regard to certain individuals. But I do think it's very context specific. I'll give you an example. One of the back in the I believe it was the 1980s. There was a case, United States versus Meinhold, where it was one of the early challenges to the constitutionality of the same-sex ban in the military. And the case went up to the lower court, had entered a nationwide defendant-oriented injunction prohibiting the government from enforcing its restriction on same-sex homosexual service members in the military. And the Supreme Court stayed the injunction as applied to everyone except for that particular plaintiff before the court. So that particular plaintiff, the injunction remained in effect. Everyone else, the injunction was stayed. And so that's an example where the government was fully prepared to continue enforcing its policy, and the court eventually allowed it to continue enforcing its policy against the third-party non-litigants. So I think that it's going to really be on a case-by-case basis. In some situations, if a single person wins, the government will stop enforcing the provision against everyone. In other cases, particularly where the government thinks, and again, rightly or wrongly, where the government believes it has a strong interest in enforcing that legal provision, where it is fairly easy to enforce that legal provision against other people, to exempt just certain people, I do think that there will be cases where it makes a difference.
I will grant the premise of the question, particularly when you're thinking about an injunction with respect to, say, FDA approval of medication. When some journalists were calling during the development of the mifepristone litigation back in May, I remember grappling with what seemed like the question of angels dancing on the head of a pin. Does it matter if it is possible to confine the scope of this injunction geographically, either to one district in Texas or the Fifth Circuit? And in some ways, I think you're right. It just doesn't matter. The FDA is not going to say, well, we recognize that this particular drug does not have approval to be marketed and sold in one part of the country, but it does in other parts of the country. That was just not going to be feasible. If we think back to the early days of the Trump administration, though, we see that there were conflicting judgments by various district courts on the legality of certain aspects of the Trump administration's travel ban. And so the way that judges would try to avoid bumping into one another, issuing these injunctions that really would put the government between a rock and a hard place, facing truly inconsistent injunctions, they narrowed the scope of the effect of those injunctions. So certain people were indeed allowed to take advantage of some injunctions. Other individuals trying to take advantage of immigration laws were not able to take advantage of those injunctions. So, I mean, it is messy. It is certainly messy. It is not ideal, but I don't think that this has become a totally academic inquiry.
I mean, didn't we just see that with the ghost gun order with the Supreme Court? The court just narrowed the scope of the order that it originally had been applicable. I thought you were the one tweeting about it.
Xing about it, right?
In the ghost gun case, right, Judge O'Connor initially issued a nationwide injunction. The court stayed the nationwide injunction. O'Connor went back and tried to issue another injunction that was only applicable to two plaintiffs. And the Fifth Circuit said, yeah, this is totally different. And the Supreme Court, I mean, didn't say anything, but basically said, no, it's not different at all. So that, if anything, Michael, I think that reinforces the suspicion that this is not about the nature of the relief. right? That at least 5 justices, perhaps the same 5 who voted for the stay the first time the Ghost Guns case got to the court in August, were of the view that the problem is with the injunction, period, not with its scope.
I would say that this has tentacles, though, beyond what we are talking about in terms of the scope of a judgment or an order. I mean, if you think back to the Perry litigation in California challenging Proposition 8, which before Windsor and Obergefell was prohibiting same-sex marriage in California, you have a trial that says this is unconstitutional under the federal constitution. For various reasons, state officials chose not to appeal. And so the question was, well, whom does this benefit? Just the 2 couples who had sued to challenge the constitutionality of Proposition 8, or every same-sex couple in California? So figuring out the scope of a judgment and relatedly the scope of an injunction continues to be with us as we engage in these kinds of high-stakes lawsuits that affect real people's lives.
Let me ask this. The benefit of the attorneys general bringing a litigation, let's say the red state attorneys general and the blue state attorneys general filing an amicus brief in opposition, has that changed the relative balance of a litigation? Have you had that experience?
We're in a 50-50 country, right? We've got 25 Democratic attorneys general. You've got 25 Republican attorneys general. You're the judge. I can't imagine that a judge is terribly surprised when they get the amicus brief from all the reds or all the blues. Do they read it? Do they make a difference? Or does the judge do what he was going to do in the first place?
So this
I don't know.
goes to the question of the politicization of
Absolutely.
the process.
It's top to bottom. And that we're in trouble. We're in real trouble here. And that division, it took a while for that partisanship to get into the AG world. It's really been the last 4 or 5 years. And for those of you relying on experience before that, as I did, teaching this course for 20 years, you've got to go change your syllabus once in a while, right? That you're really seeing this very, very discouraging change. And yet, to stand up for the assistant AGs out there in America, there's about 14,000 of them. They're out there doing their job today. They're representing their agencies. They're prosecuting criminals. They're giving honest opinions. They're really kind of working this through. This is at the top. This is at the top. This is at the AG level, and sadly, increasingly at the SG level, where SGs now go to the Republican AG Association's meetings. That was always verboten, that the AG would go to these partisan meetings but not let their staff come. And now the staff is coming in, actually making presentation at events where private parties pay $100,000, $500,000 to come in. You can't get in the door unless you pay money to listening to assistant AGs talk. It's terrible practice. I never go. I don't go to either one. No surprise to any of you, I'm a Democrat. I don't go to Doug. I don't go to Rog. I don't go to either one.
Anything else? Yes. Professor?
Sure. Quick question.
Professor Reiner.
Does anyone distinguish between what we're calling nationwide injunctions, sorry, Michael, and actions under the APA to vacate an agency rule or regulation? I mean, presumably because if the rule is vacated, it applies. I don't know that you can have a rule that's vacated only as to the individual who's mounting the agency, the challenge under the APA.
So there certainly have been people who have argued that to set aside a regulation under the APA means to set it aside as it applies to the specific individuals. Now, as I was mentioning in the case of mifepristone and the FDA, it's really hard to imagine what that looks like in the mine run of cases. And so I think in a lot of ways that dovetails with Steve's question on so many of these issues. Is there a practical effect to trying to say, well, this is a nationwide injunction as opposed to this is an invalidation of a regulation? My view is that call it what you will, in 90+% of situations, it is going to look the same. And maybe that is the reason why the advent of so-called nationwide injunctions, at least in their modern incarnation in the 1960s, flew under the radar for so long. And that it's not until we get outside of the APA context that a lot of people during the George W. Bush administration were saying, hold on, what is going on here? Even though in the APA context, it had seemed unremarkable for at least a couple of decades.
Anyone else? Go ahead.
I think that's exactly right. A few thoughts on that. John Harrison has written on this. One of the issues deals with whether set aside actually was intended to apply to regulations as opposed to just orders, which the result of administrative judgments, which obviously would then be binding just with regard to particular parties. I think another underlying issue is, right, to the extent that Congress were purporting to authorize, right, federal courts to grant relief beyond the bounds of the Article III case or controversy, but before the court, or to grant relief to third-party non-litigants, right, there would be an argument that this is basically just, like TransUnion all over again, or Spokio all over again, that simply the statute would be unconstitutional as applied in those circumstances, or at least the federal court would lack jurisdiction to grant the full scope of statutory relief. Certainly the D.C. Circuit back in the 1960s expressed skepticism about the notion of, even in the context of invalidating administrative issuances under the APA, going beyond the particular parties to the case, looked to see what relief the particular plaintiffs had standing on. The one other detail I just wanted to bring up, it's not that in the 1960s everything started going crazy. It's that the 1960s you start to see some of these cases coming up. It really, in my view, really wasn't until the past 8 years, maybe 10 years or so, that this was an explosion. And in large part, I would suggest, simply because the issue, if you go back and you look at the issue wasn't being briefed. Like, in a lot of these cases, just like broad sweeping relief was being granted, and there'd be like a page of argument in the brief about it. It just, for whatever reason, to the extent it makes sense to say, like, the legal culture, the judicial culture, just wasn't really focused on this issue until, perhaps as a result of extreme polarization, until we started to see very high profile, recently adopted policies from both from both presidents. The end of George W. Bush, President Obama, President Trump starts getting struck down. It's something that gets the attention of both political parties, that their preferred, recently adopted policies become targeted.
Okay. Well, we've left the tough questions for Professor Vladek's panel, and I want to thank the panel for a very interesting discussion.
I want to thank the panel as well. It's very stimulating. As a former assistant attorney general, I was particularly interested in the attorney general's comments. Thank you so much, all of you, for being here. It was very thought-provoking.